May it please the Court, Tanner Wadsworth for Sergio Sanchez Lozano, who is the appellant in this case and the father of the child. This case is resolved by the evidentiary standard for the grave risk exception under the Hague Convention and by the scope of the father's express authorization for his son to travel to the United States as opposed to his private expectation. Our briefing explains in detail why the district court's order should be reversed, but the heart of our case is this. First, the record here does not constitute clear and convincing evidence that returning the child to the state of its habitual residence would place it at grave risk of harm. And second, that because less than 1 year passed between the date that the child's retention in the United States became wrongful and the date that proceedings were initiated in the district court, the well-settled exception is not applicable here. I'll turn to those points now, unless there are any initial questions. As for the grave risk exception, the district court erred as a matter of law when holding on this thin record that there was a grave risk of harm to the child inherent in returning the child to Mexico, not to the custody or the house of his father, but to the nation of Mexico. The grave risk exception allows district judges to decline to return children to states when doing so would place them at grave risk of harm, physical or psychological harm. And the courts interpreting this narrow exception have found it applicable in situations where it would mean returning the child to a zone of war or famine or disease. This court, in the recent Galaviz case, made it very clear that the grave risk exception is not a vehicle for litigating garden variety family law issues like the custodial fitness of a parent. In this case,
I don't know that it's garden variety custodial fitness to say that you have ties to a cartel and that in fact your brother is off missing because of the ties to the cartel. The district court clearly credited the mother's testimony that the father had ties to a cartel. Don't we have to defer to that?
No, Your Honor.
Actually, the district court was free to believe the mother's testimony.
Yes, there's two.
So you're saying ties to a cartel are not enough to say you're at grave risk. Is that what you're arguing? Because we're going to accept that you have the ties to the cartel, right? You've got to take that because there's testimony and the district court credited it.
We disputed that in our brief, and we can discuss now why.
Let's do that because that's the first hurdle, is the district court credited the mother's testimony. Even if you thought it was thin, there is testimony and the district court chose to credit it.
Yes. Let's talk about what the appellee told the judge at the evidentiary hearing. She said at the very end of cross-examination that the appellant, the father here, has ties to a drug cartel. She couldn't define what those ties were. She couldn't define what the cartel was. When the judge pressed her, she said that the appellant's brother disappeared. When the judge asked her how she knew that that was related to the cartel, she said, nobody knows, but the family has suppositions. And when pressed again, she said, the family has a lot of problems, there's a lot of contention, and she understood that the appellant's brother disappeared after having an affair with a member of a cartel. Well,
Cartel ever threatened Ms. Perez or the child?
No, Your Honor. There's nothing in the record that any cartel or anyone ever threatened the child. There's also no evidence in the record that the cartel ever threatened the mother in this case. What we know from the Galaviz case is that
the brother-in-law is missing from the cartel.
The father-in-law is missing, and they have suppositions.
Father-in-law or brother-in-law?
So the appellant's brother,
Yeah.
the child's uncle.
Yes. No father-in-law, brother-in-law.
Excuse me, yes. The Galaviz case said that mere speculation does not meet the clear and convincing evidence burden. The record here is so thin that it accounts for nothing more than speculation. Galaviz also said that both the finding of underlying facts and whether those facts amount in their totality to a clear and convincing evidence standard both fall under that clear and convincing evidence standard. So there's not clear and convincing evidence from the record without us reaching into speculation to find that The father,
You say that he has connection to the Durango drug traffickers, is that not correct?
which document are you reading from?
Maybe I'm reading from something,
I know it says that in the briefs.
no, I'm reading from what I thought were the findings.
The,
The findings say that.
the district court judge found that there are ties to a drug cartel, although the district court couldn't define the extent of those cartels or what the cartel was, and it was never able to identify what harm, if any, would result to the child from those ties. So I'm not going to stand here and tell you that it's a great thing to have ties to the cartel, even assuming that's true, which we dispute. We think that there's a lack of evidentiary basis for that finding. But you don't have to reach into the record, and you don't have to overturn any.
High standard to overturn an evidentiary basis when the district court has made specific findings of fact and conclusions of law based upon that he's related to a particular cartel.
There wasn't that finding here.
It says the risk is much closer and more material because of petitioner's connection to the Durango drug traffickers. Minute entry, October 28, 2024, testimony of respondent. The father of my children is involved with the narco drug dealers that are in Durango.
Right. There was no
So there's-
finding of a specific cartel. The Durango is a state in Mexico.
Well, it's a place, but
It is a place.
Durango drug traffickers in the place of Durango, and that there are specific cartels. It's not just a general cartel presence, because the district court, in fact, differentiates a general cartel presence. He collects cases saying general cartel presence may not be enough. He wouldn't do that if he was saying this was general cartel presence.
Your Honor, I would say that he's trying to thread a needle there that can't be threaded. If the cases say that generalized cartel violence in a state can't constitute a grave risk, and then he's saying because of this petitioner's unspecified ties to drug dealers in Durango, that is prima facie, just it has to do with the location and the violence there.
What about his history of substances abuse, including using cocaine 8 days before the hearing? Certainly that would place a child in grave danger to be around a cocaine-using parent who's also perhaps associated with the drug cartel.
Your Honor, concerns about a parent's character.
That's not character, that's safety, that's health and safety. It's not just besmirching a character. You're not medically capable of taking care of a child if you are on cocaine.
But there was no such finding below. That's not what the district court found.
He is a longtime cocaine addict whose cartilage in his nose is perforated.
Yes, there was no finding outside of
That's
you
the
and I.
district court's findings I'm reading from.
Yes, Your Honor. Let me back up and explain why we know from Galaviz, which is a great case for us, where, by the way, there were also allegations very similar to the allegations here, that it can't be a grave risk if it really boils down to concerns about a parent's custodial fitness. Yes, cocaine use, we don't like to see that in parents. We don't like to see alcohol abuse. The ties to a cartel thing, even if we assume and we dispute this, that is a factual finding, our point is that you don't have to overturn a factual finding here, because in Galaviz, there were two things. There was the factual finding, and then the judge's finding that all those findings amounted to a grave risk. The lower court erred as a matter of law in finding that all of these things added up to a grave risk. So our position is that was an error of law. Let's talk about some of the cases that have considered cocaine, that have considered alcohol, and even spousal abuse, because all those things are in this record.
No, none of those cases are binding on this circuit, are they?
Your Honor, the Galaviz case?
Right, but tell me what that holds that helps you.
Galaviz holds that allegations of domestic violence, sporadic incidents, were not enough to satisfy the standard. It reiterated that the grave risk exception is a narrow exception. It reiterated that the purpose of the exception is just to restore the pre-abduction status quo. The law in Hague Convention cases is relatively easy. Human issues involved can make it difficult to follow. We don't like dealing with issues of where children grow up. We don't like dealing with issues of who's going to be the better parent. And what the convention says is we don't have to deal with those issues at all. The best interests of the child are well supported when the courts of the home country make those determinations. The court in Friedrich said that concerns about grave risk, the vast majority evaporate when we decide to trust the courts of the home country. So the issue in this case boils down to whether we trust the family court of Durango, Mexico, which already has jurisdiction over this case, which has already entered a custody order in this case, whether we trust them to protect the child, and if not.
I'm sorry, so are you saying that our case law does or does not bind us to find that cartel involvement and drug addiction don't pose a grave risk for a child? What case law that we're bound by says that?
In the Madrigal case, this court considered it was a Hague Convention case. There was a death threat to the mother through email. It was a specific threat, and the mother was also accused of a crime. There was an arrest warrant. This court held that neither of those facts, her potential criminal activities and vague death threats specifically aimed at a person, was not enough to satisfy the grave risk. Here, we don't have any threats at anyone, and we don't have any allegations of any kind of criminal activity whatsoever, let alone an arrest warrant. This falls far short of the standard in Madrigal. The reason why the standard in Friedrich for the grave risk exception, which is zones of war, famine, disease, makes sense here, is because we're not returning, a return order would not return the child to the custody of his father or even to his household. It would merely return the child to Mexican jurisdiction.
That's a Sixth Circuit case.
It is, Your Honor. It's been cited many times by this court, and it is.
It has been cited. Yeah, we're very familiar with knee exeat rights. I know Judge Haynes has written a lot. I'm sure Judge Clement has. My very first case, a knee exeat rights, was reversed by the Supreme Court in the Abbott case, which is the quintessential knee exeat case. So we're very familiar with how this works. I'm asking about specifics in this context. So can you, and I know that this is an area that you litigate in, so can you help us? Specifics in this context with cartels and drug use, whether or not that can be enough.
These specific facts, Your Honor, of course have not been litigated before this court. The vast majority of the authority establishes a bar for the grave risk exception that is much higher than the record here. At the district court, the appellee bore the burden of proof on those points, and that the record is so thin here that the district court really was not able to find or identify any kind of risk that would happen to the child.
He wrote at length for pages about the grave risk exception and why he was able to identify the grave risk.
And, Your Honor, the reasoning was the appellant abuses alcohol, he recreationally uses cocaine, which he buys from a drug dealer in Durango, and that he has ties to drug dealers in Durango, which one necessarily must have to purchase drugs for recreational use in Durango.
Was there credible evidence to that effect, to the fact that he would driven the child while he was under the influence, or that he'd used drugs or alcohol in the child's presence? Was there credible evidence on those allegations?
There was no evidence or allegations that that had happened before. The appellee testified that she had concerns about that happening. But again, Your Honor, mere speculation does not meet the clear and convincing evidence burden. If we are going to apply the clear and convincing evidence standard here, it has to be higher than the facts that the district court found below.
Can you talk about the well-settled? Are you timely or not?
We're timely, Your Honor. In
Why?
the Dietz case, this court said that when a trip that's meant to be temporary and a parent has reason to understand that it will actually be permanent, that's when a retention becomes wrongful. I'll say it again so it makes sense. A retention becomes wrongful when a trip that was initially meant to be temporary, the left-behind parent knows that it'll be permanent. In this case, that happened in August of 2023. The parties executed I'll return to that in rebuttal. Thank you.
No, no, can you,
Yes,
sorry.
absolutely. There is an agreement in this case, an express agreement that both of the parties signed, and that agreement said, under Article 421 of the Mexican Civil Code, which addresses parental authority, it's the statute that says when a child is in parental authority, it may not leave the country without the agreement of all the parents that are exercising it. They invoked that statute. They made an agreement saying that the child could travel to, in, and from the United States for up to 1 year. At trial, the appellant testified that notwithstanding that agreement, he expected the child to be gone for 2 or 3 months. If I give you a pen and I say you can have it all day, but I only expect you to have it for 3 hours, I can't say you've stolen the pen after 3 hours because I told you we had an express grant of consent for a day. My private expectations.
That in this context?
Your Honor, it's well understood in the contract context. I'm not aware of a case that would bind this court in the Hague Convention context.
Okay, well settled is not dispositive, though. You can, if they win on grave harm, then it doesn't matter whether they win on well settled, right?
They're independent.
Yes,
exceptions.
independent. You have to win both in order for you to win today, right?
Yes.
Okay. You talk about the Rivera case that you did a 28J, but in that case, that child is not a U.S. citizen. And in fact, the court makes a big deal that any rights the child has are derivative of the mother's rights. In this case, the child is a citizen, right? How does that, and we've had a lot of cases in the news in the world where they're citizens and they have their independent rights. How does that complicate this situation that the child is a citizen? It certainly makes Rivera not on point, but because the reasoning of Rivera is all about how the mother doesn't have any rights, and so of course the child doesn't have any rights. But how does it impact this dispute, the fact that the child independently is a citizen of the United States?
I disagree that it makes Guevara distinguishable. Citizenship is irrelevant here. The standard for finding a child well settled is significant connections, substantial evidence of significant connections to its community. The child here, who's 9 years old, is a citizen, but the remedy under the Hague Convention is not a deportation. The remedy is just returning him so that the parents can work out their custody issue.
Is that the way it works in this context? Because we know that like in the INS context, people have said, oh, the child citizen has their own rights and gets to have an ad litem or something to support their rights to remain in the United States. Does this child have any of his or her own rights to be in the United States, separate and apart from the Hague Convention? They normally are not citizens of the United States in this context. Usually they're citizens of 2 other countries and happen to be here. This is unique in the ones I've seen. So does that have any role to play in this case whatsoever?
No, Your Honor, because to the extent that citizenship is a connection to the United States, is it a substantial connection that would prevent the Mexican court from exercising its jurisdiction? This case is.
If the child were 14, would that be a different answer because they would have a right to at least under the local laws where they exist, to have a preference, and that would have to be taken into account.
To the extent that citizenship creates connections with the home community, which I think of paying taxes or selective service or voting, those would all be relevant. Here, the issue is really the father's parental rights. The child, it may have rights, but the problem is that under Mexican law, the father has a right to determine where his child lives, and that father is still exercising parental rights, and the mother violated those rights by bringing the child here and keeping it indefinitely.
So would the mother be returned with the child to Mexico?
At the district court below, the mother testified that she would return with the child if there was a return order, which also supports why the record here doesn't support grave risk. We're not returning the child to the father's custody. That's for the Mexican court. The court in Galaviz and in Friedrich reminded us that we're really not supposed to prioritize our culture or our values over others. The convention says that the family courts of the home country are best positioned to decide who's the best parent to exercise custody and what's in the best interest of the child.
Thank you.
Thank you.
Save time for rebuttal. You can have 3 extra minutes if you need them, because we went over with him.
Good morning, Your Honors. May it please the Court. Your Honor, I'd first like to address some of the issues that counsel discussed, beginning with the U.S. citizenship, which I think is probably the most pivotal part of this case. Yes, the child has rights. Yes, he has rights under the 14th Amendment. He has rights to remain here. This fact is brought by the evidence that both parents worked together to assure that both of their children were born here in the U.S. They're 12 years apart. They have a U.S. citizen son who has just turned 21 on September 15th. He's here. They have this child, and both parents testified that they were in agreement with having both children here in the United States so that the children could be availed of all of the rights of U.S. citizenship. Specifically, not only to give them a jump start on being here, but that goes very much into both of the defenses that were raised and that the court found were sufficient. So I'm going to go into first some of the things that counsel stated. First, he said that the district court didn't have to define the ties to, did have to define the ties to the cartel. That is not true, Your Honor. The cartel are not like gang members. They don't have different names. They're located where they're located. The district court had no obligation to define what the petitioner's specific ties to the cartel were, only to find that he was affiliated and that he was a member of the cartel, and that...
He says that doesn't matter.
I understand what he says, but it matters.
Does it, under the law, whether the father is a member of a cartel, does that matter, or has affiliations with the cartel?
Absolutely. Absolutely. And going to the cases that counsel cited, if you look at those cases individually, which as the court asserted, some of them are only persuasive authority and some of them are not mandatory. If you look at Soto, Soto only talks about domestic violence. You look at Bernal, Bernal only talks about the presence of the cartel. You look at Guevara, there's no grave risk. You look at Larby, they're talking about lengthy litigation. Each of these cases only specified either a grave threat that was in the home or a grave threat that was outside, because either the country was war-torn or they tried to say, oh, cartel are present, that makes it dangerous. That's not what we're saying here. The petitioner himself has created a situation that's both dangerous inside of the home and outside of the home. Why? Because he chooses to live his life the way that he does. He gets away with things. He's a member of the legal community. He has weight over there. At any time that the police have been involved in their lives, if you looked at the record, which...
Member of the legal community using cocaine as often as the record says?
Yes, Your Honor. When my first question to him was when was the last time he used cocaine, he told me 8 days before. In his deposition, I asked him how often he used cocaine. He said monthly. I asked him if he had, and then he told me that he was a lawyer and that his brother, who's gone missing for 12 years, was also a lawyer. And so even despite the fact that he told me he only used cocaine once a month, the deposition was not too long before the trial, and he had no problem telling me that he was using cocaine right before the trial. That being said, he appeared via Zoom, and Chief Justice O'Connor was able to look at his demeanor, and I asked him the question, are you under the influence today? And of course he denied that, along with every other possible negative fact. He testified to nothing negative. He admitted nothing bad except for his use of cocaine. Why? Because then he didn't think there was anything wrong with it. And being a member of the legal community, that creates another danger. Not only are you affiliated with the cartel, a member of the cartel, but now you've also got the courts. And if you look at the situation with the court, in order for a court order to be enforced, we have to turn to law enforcement. And in this case, each time that my client turned to law enforcement, somehow he got what he wanted. So the first time she talks about is when the older son, Juan, is 15 years old. He's with another woman. She goes to confront him about it. He beats her so bad that he blackens both of her eyes. There's evidence in the record that shows what she looked like. She calls her son to come defend her. Her son leaves the younger child, the child in this case, at home alone so he can go help his mother. He gets there, and what do the police officers do? They arrest the 15-year-old. They leave the father, they look at the mother, they leave her where she's at, and he chooses to press charges against his own son.
But is that, that may say we would do something different if we were in the local domestic courts there. How does that apply to the Hague Convention?
If you look at his petition, if you look at the very first document that he filed with the Secretary of Foreign Affairs, he's not asking that his children return home. He says it in his own words in Exhibit F, page 52 of the record. He wants these children to return to he talks about his other child, how his other child has aged out, but he wants the younger child returned specifically to the home where he kicked his children out of, and he puts the address in his application, which is the second incident with the police officers. He'd been living outside of the home, and the mother had been living there with the two boys after the divorce, and she'd been running a hair salon out of the home. Well, he had been hospitalized for pancreatitis due to his alcoholism, had been living in another state for about over a year, and then he decided he wanted to move back into his home. So he calls mom and he says, "I'm moving back in tomorrow, get your stuff and get out." And she says, "We can't get out in one day." "I don't care." He comes the next day, he tells her leave, she calls the police. The police tell her, fit whatever you can fit in your car and go.
What is your best case that this is enough under the Hague Convention?
This is the irony of the answer to that question. Counsel sent you a case Friday, Guevara, and he said that, quote unquote, it stands on all fours. Guevara helps us because Guevara outlines the well-settled exception and talks about how the analysis should be applied. Further, Guevara helps us because, as you stated before, none of the children in any of these cases are U.S. citizens. In the Guevara case, if I remember correctly, I believe that they were from Venezuela, they were undergoing an asylum petition, and they were in the process of potential deportation if their petition was not granted. That's not what we have in this case. The parties intentionally came here so that their children could be U.S. citizens, and now my client has a pathway to citizenship herself because she has a 21-year-old ready to sponsor her. And I will say there is a finding that my client is here illegally. However, that's incorrect. If you look at the record, she states that she came in with a visitor's visa and she has not overstayed her visit. So if she's able to adjust through her son, she could adjust here in the United States. However, if she leaves at any time before she becomes a resident, she's barred for life. And now you have a mother of 2 U.S. citizens that is stuck in Mexico that can never come to the United States, and potentially you are punishing this child to go to Mexico to a situation where essentially we're not talking about just a brother going missing, but a child going missing as well. When we look at the grave risk factors going into that, and what the court found, there's no other case on point with this one that has as many issues or as many points that hit on the grave risk assessment.
What are those?
Well, first we talk about what we've already talked about, which is his cartel ties. Then we talk about the fact that he's a member of the legal community. Then we have that he's able to do whatever he wants when the police force comes into play. I asked him specifically, do you have any friends in the legal community? He said no. Do you have any friends in the police force? He said no. Do you have any friends in the judiciary? He said no. He wasn't going to admit that he wields power in Mexico. But essentially, if you look at the timeline of facts, he was able to not only move back into his house, leave his children and his wife homeless in the last 6 months that they were in Mexico, but then after, he tells her, it's okay for you to come to the United States with the children, and just changes his mind. What's going to happen if the child is sent back over there?
So is the beatings, did the district court rely on the beatings?
He did. There was evidence regarding him beating the oldest son more regularly, and how violent the beatings were of the oldest son. And then we discussed how many times that he beat his wife, and she testified that there were times that he would beat her 5 times in a month. And then we discussed his treatment of the child in this case, and he denied that he overdid the corporal punishment. But my client testified to the fact that not only did he beat the child, but he also locked the child in the restroom for several hours and wouldn't let her get him out until he said so. So when counsel says that there was no showing that the child was ever put in danger, that's incorrect. Not only was he specifically put in danger by his father, but his father basically rendered him homeless. So I don't know how counsel could reach that conclusion. Now, to me, Your Honor, this is more of a disagreement on the fact finding than a presentation on this case that the court aired. And going to fact finding, I do want to discuss, because I think it's important, the factors regarding the well-settled exception. Because counsel makes an argument that we didn't meet the 1-year burden because there's some thing in the actual petition itself. In the first petition, the petitioner says, I did not know that my children were going to stay until August. However, there's nothing in the record. There's no testimony, there's no evidence that shows that fact. He says it in the petition. It's not in his verified statement. It's just a blanket paragraph of the petition, which we specifically objected and denied that. And then it was never developed in any testimony or any evidence after that. So the only evidence that the court really had that was concrete was this travel document, which was testified to. And if you look at the travel document doesn't say that my client can travel with the children for a year. What it says is that the children can travel with their aunt and uncle between this date and this date. That's what that travel document says. The only testimony that showed that he had rescinded his consent for the children to be here was his own testimony when he stated, I only wanted them to be there for 3 months. And then he says, I didn't know when my children entered the U.S.
Did the district court credit that testimony?
The 3 months, yes. That was one of the things that the court actually gave him credence on, that he believed him on, because my client testified that, no, it took me 5 months to convince him to let me move here with the kids, and then he just changed his mind, because he changes his mind a lot. He said, no, I wanted my kids here only 3 months. So the court did believe him on that point. So if he did believe him on that point, then later he says, I didn't know when my children entered the U.S. And then he says, I didn't know that my children were going to stay here. But I'm going to direct you once again to his application before the Secretary of Foreign Affairs, where in his first line, which is Exhibit F of his complaint, page 52, he states, the abduction or retention of the minor occurred the first days of January 2023, when the mother of my children took my children from their usual place of residence in Santa Maria de Oro, Durango, usual place where my children and we, their parents, have lived for approximately 16 years. He knew his children were here. He knew they entered the first days of January. In his own testimony, he states that he was talking to the older son twice a week. His counsel sent us a request for admission, as we read into the record. Isn't it true that you visited your children at least once every few months? That somehow between the time that we were sent the admissions and when he testified at trial, his testimony became, oh, I saw them biweekly, and then I saw them twice a week, and then I talked to them twice a week. So here he admits that he knew that his children were here in the U.S. the first days of January of 2023. In his petition, he states, I didn't know where my children were until December, when I decided to finally start paying some child support, and my oldest son sent me some bank information, and then I was able to get their address. Well, I don't know whether the court really paid much credence to that, but I will say that in his application that he files before he gets the letter from the Secretary of Foreign Affairs that tells him where they live, he's already put their address in this application. It's redacted. However, the zip code, the city, state, and zip code are not 76134, where my client still resides. There was a lot of inconsistencies in Mr. Sanchez's testimony. There were a lot of inconsistencies between his testimony and the legal argument as well. But really, I do think it's important to take a little bit of time to go into the factors regarding the well-settled exception as well, Your Honors, because as you know, the way that you review that is by clear and convincing evidence on the factors, but the legal conclusion de novo. So I'd like to give you some information that I think would be helpful in your assessment of that particular part of this case. So as you know, and once again was established by the Guevara case, which counsel reintroduced to the court on Friday, there are 7 factors regarding the well-settled exception. The child's age, the stability and duration of the child's residence in the new environment, whether the child attends school or daycare consistently, whether the child has friends or relatives in the new area, and the child's participation in community or extracurricular events. I'm going to talk about those 5 because those 5 move into each other. They go together. When we talk about age, when this first started, the child was 6 years old, now he's 9. He will have been in the United States for 3 years in January. He started having issues with being able to integrate in school because he did not speak English. And so at the very beginning, counsel presented some evidence that the child was doing very poorly in school when he first started school. However, we showed the court that not only did he do so much better within a year, he went from first grade to second grade and then skipped to third grade in 2 years. He made the honor roll. He was in UIL, and he actually participates in debate. A child who enters this country cannot speak English and then later excels so much that now he's debating. We have to take that into consideration regarding his stability and his ability to be well settled here. Furthermore, when there was a court that found that a child who was 7 years old was not capable of forming the kind of enduring attachments that the convention seemed sufficient to override the return. However, another part of this case that matters so much is his brother. He has a U.S. citizen older brother who is not granted, he's a derivative of his mother because he was born of his mother, but that is a direct relationship. If we were to say this child cannot form enduring attachments because of his age, and he cannot do so independent of his mother, I don't think that the convention meant, okay, well, get him a car and let him start driving and trying to make his own friends. He goes to school. He has teachers who are going to miss him, his counselor. He has church, which my client had testified that they were becoming members of, and he has an older brother at home. That couldn't be a more meaningful contact that he has here. Again, a U.S. citizen brother.
What happens if you were not to prevail? I'm just hypothetically, not foreshadowing, and the mother doesn't go back with him, but the custody agreement says that it's with the mother in that place. So how does that work? Do they have to? They would have to go to that court and get that changed or something? I'm not sure that she's required to go back just because that's what the custody arrangement. I'm going to ask the other side that too.
Not necessarily, Your Honor. So I'm going to answer that question in 2 different ways. Number one, this court is limited by the record. Individuals like this individual, live a formulaic life. Sooner or later, they get caught, things happen, the cartel gets nervous. If the cartel wants you, they'll take you. If they want something from you, they'll take your family. In this case, the court in Mexico stated that she has sole custody and he has visitation rights. If she does not return to Mexico, then the court could essentially give him.
The court will have to determine what to do with the child when the child arrives on their doorstep with no person that has custody.
Correct. But the reality is the situation, Your Honor, is that
if she did do that.
Yeah.
But she said that she would go back with him. But,
yeah.
I mean, she's not bound to do that.
Correct. She's not. That's absolutely true. That's absolutely true. And in addition to that, the problem with her not going back is that, now we're talking about him being with a violent drug abuser, alcoholic, cartel member, versus a home here where he's loved, supported, protected. That's what this court would essentially be doing. And just let me clarify, this is not about punishing the parents, but it's also not about punishing the child. Do we trust the family court to protect the child? That was the question you asked. The answer is no. What good does the court system do if you don't have law enforcement to back it up? He talks about how in Madrigal there were death threats. Okay, well, let's talk about this case. Again, we can take every single case that has appeared before this court and we can say, well, this wasn't enough, this wasn't enough, this wasn't enough, return the child. This is the case that the Hague Convention defenses were designed for. All of the facts that go into this, how many more different combination of things do you want in order to meet the burden? And Judge O'Connor saw that, and he knew that. And he saw that when he weighed the credibility of the witnesses. He saw that when he heard the testimony. He saw that when he found in one of his first lines in his findings of fact that this man, who has connections to a Mexican drug cartel, initiated the suit. And he goes on to talk about how, with his connections, he was able to do all of these heinous things to this woman and this child before you in this court. I do want to talk a little bit more about the well-settled exception, Your Honor. I would like to talk about how, once again, we're talking about him having excelled and being where he is. We talk about the respondent's employment and financial stability. She has been able to not only stay in the same home that she's lived in since she got here, she's also been able to retain me. I'm here before you today. The other side, I will tell you, he did testify that he's not paying any legal fees. All of this is for free, and it's kind of like the rest of his life. His office, he's been in it for years, couldn't tell me why his rent is free. He moves to a new office, it's free. He doesn't have to pay for it. I asked him 3 times, how do you pay your drug dealer? Never got an answer from him. I asked him, where's your drug dealer? Counsel objected. Never got an answer from him. And if we talk, and the last factor is the immigration status of the respondent and the child. I will assert to this court again, my client testified she didn't just enter legally. She did not just enter legally. She is here legally. She entered legally, and now she has a son who within a year she could potentially become a U.S. resident, but she is not illegal here. And the problem, again, with returning this child is that you don't just punish one child, you punish them both. I know that the court is extremely conservative in returning these children, and most of the time these district courts are overturned. However, I know that that's because this court does not look favorably on wrongdoers. But in this case, the petitioner is the wrongdoer.
Thank you. We have your argument.
Thank you, Your Honor. And thank you, Your Honors, for your time.
At the outset, there were certain things in Appellee's argument that were simply not in the record. The information about the child's participation in debate, and Appellee also apparently is challenging some of Judge O'Connor's other findings about the Appellee being present in the country illegal and her new husband also being illegal in this country.
Are you saying the well-settled exception is going to turn on whether the child is successfully doing debate or not?
No, but I thought it was worth observing. What there is not in this case is a specific example of harm that would result.
That's not to criticize debate, which is a useful activity for many people. Go ahead.
There's not clear and convincing evidence of harm to the child that would befall from returning to Mexico. There's been no evidence. The child lived in Durango for 6 years, and there's no evidence that during that time anything bad happened to the child. The The convention is designed to return the child to Mexico, and Mexico is a developed country that has developed courts with ad litem systems that are similar to ours. They have the machinery for resolving parental disputes and assigning custody of children and protecting children, just like we do. The question before the court is whether we're going to uphold the convention and its return remedy and deter future parents from abducting children. And what the lower court did is it expanded 2 narrow exceptions to that return remedy wider than I'm aware that they've ever been expanded before. The wider those exceptions become, the less effective the convention becomes at deterring parental abduction.
Do you dispute that the child was ever present whenever any abuse of either the son or the wife took place?
Yes, Your Honor.
You dispute that the child never saw the aftermath of those abusive behaviors?
The child was around 3 years old when this was happening. The last documented instance of a parental fight,
Abuse?
parental abuse, was many, many years ago. We went into this carefully in discovery and at the hearing, and there is no evidence that the appellant here ever did drugs in the presence of the child, ever hurt his ex-wife in the presence of the child, or ever hurt the child itself outside of ordinary parental discipline, spanking and...
Drugs during the proceedings in this case?
Pardon?
Was he on drugs during the proceedings in these cases?
No, Your Honor, not to my knowledge. He did say he'd had cocaine 8 days before. So...
But he was not perceived by the district court to have been on drugs during the proceedings in this case?
No, he was asked and denied.
Because of his behavior during the hearing?
No, Your Honor.
Okay.
That's not in the record, and it was not in my observation at the hearing. So we don't like these cases. These are hard cases. They involve children. They involve...
What about the other child?
He's 21 years old now.
When he was there, was he abused in front, and was he ever abused in front of this much younger child?
The testimony that he gave at the hearing, or that his mother gave, was that he described it as like being in a boxing ring. He was an older son. He fought with his dad. The appellant in this case only has one arm. That's also in the record. So there is in the record evidence of fights between the older son and the father. We think that the Galaviz case and the Friedrichs case also establish that that's the kind of sporadic and isolated incident that's not directed at the child that doesn't rise to the grave risk concern. The problem is that if we get an opinion out of this case that says you can come to the United States and you can say that the parent you left behind does drugs, is generally a bad husband, that returning the child to him will put the child in a bad situation, but not a gravely bad situation.
That's not what the opinion's going to say. If it were going to say, even if you were not to prevail, it's not going to say we don't find graveness, but graveness it doesn't matter. So that's I assume you wouldn't expect us to write an opinion that wouldn't obey the law. You would have to find graveness or uphold the finding of graveness.
That's right. Clear and convincing evidence of a risk that's not just substantial but grave. I'll briefly talk about some of the cases where that's been enough. They're all in our brief, and all of them support our position. In Garcia versus Ramses, there was testimony that a father was connected to the mafia. That wasn't enough. In Wirtz versus Wirtz, there was massive, that's actually a case where there was enough, and it wasn't, the drugs weren't enough. So there was a specific risk to the child, which was that the mother's drug abuse, which was enormous, brought her into contact with a man named John, who was a known child molester. So here we have a specific risk of harm to the child. It wasn't just we're worried about mom, we're worried that she's doing bad stuff.
You have your cases in their brief. Did you, you heard the question to the other side. You argued to us, oh, well, he's going to be with his mother, so he's going to be safe, because that's what the Mexican court wisely ordered. That's not necessarily true, is it, at this point?
That was what she said below. The reason, the way this case came to us is that the appellant went to the Mexican authorities, who went to the United States State Department who reached out to counsel. These Hague Convention matters are coordinated between state departments of countries. So the Mexican equivalent of the State Department oversees these cases in Mexico. They have the capacity to take the child, protect it. The point is not that we're deporting the child to Mexico and that it can never come back. The point is that there's another court that has jurisdiction over this custody dispute. The mother should return with the child.
But we don't know that the child will be with the mother if the child is returned. And so we don't know that the child will be safe because the child will be with the mother, which was what you argued. You said, oh, the mother will take care of the child when they're returned. And we don't know that.
The child would be safe, not necessarily because it would be with the mother. That's the mother's decision.
Exactly. You believe that the system will just protect the child.
But it's
And by the way, the child is not an it. I know we're doing it because you don't want to do male or female or some other derivation of that, but it's not an it. Okay, go ahead.
The child is a he, and once this custody dispute is resolved, he can return to the United States. Thank you.
Thank you.